Discrimination under the Michigan Elliot Larsen Civil Rights Act, presented by Katelyn Beebe. What is the Michigan Elliot Larsen Civil Rights Act? The Elliot Larsen Civil Rights Act, or Public Act 453 of 1976, prohibits the discrimination of certain protected classes in Michigan. The law is unique to Michigan only and expands Title VII of the Civil Rights Act of 1964. The main difference between the two is that the ELCRA is on a state level, while Title VII is federal. The ELCRA protects based on religion, race, color, national origin, age, sex, height, weight, family status or marital status, housing, education, and access to public accommodations. It is important to note that Title VII prohibits employment discrimination based on race, color, religion, sex, and national origin only. So, with the ELCRA, you add in height, weight, family status, marital status, housing, education, and access to public accommodations along with age. More about the Michigan Elliot Larsen Civil Rights Act. The Michigan Elliot Larsen Civil Rights Act was named after the two main sponsors, Daisy Elliott, a Democrat from Detroit, and Melvin Larsen, a Republican from Oxford. The law was passed by Michigan legislature in 1976, but wasn't signed into law until January 13, 1977, by Governor William McKellen. Also, it wasn't until March 31, 1977, when it went into effect. The ELCRA has been amended either directly or indirectly nearly 20 times to refine the law, its enforcement, and add protections for groups or classifications not originally named in the Act, such as height and weight. In 2019, legislation was introduced to expand the Act by including sexual orientation and gender identity as protected classes. Federal and state non-discrimination laws and regulations that work with the ELCRA. There are both federal and state laws that work with the ELCRA, and some federal laws that most people are familiar with is the Title VII of the Civil Rights Act of 1964, Civil Rights Act of 1991, the Equal Pay Act of 1963, Age Discrimination in Employment Act of 1967, Title I of the Americans with Disabilities Act of 1990, and some state laws that also work with the ELCRA on a state level are the Michigan Ethnic Intimidation Act of 1998. This provides criminal law protections from individuals who threaten or actually cause physical contact or damage to a person or property because of race, color, religion, gender, or national origin. Next, Michigan Persons with Disabilities Civil Rights Act. It's an act to define the civil rights of a person with disabilities, to prohibit discriminatory practices, policies, and custom in the exercise of those rights, to prescribe penalties and to provide remedies, and to provide for the promulgations of rules. The last one that I have to show everyone is the Michigan Civil Rights Initiative, Proposition 2. This bans programs in public hiring, public employment, and public education that give preferential treatment to or discriminate against individuals on the basis of race, gender, ethnicity, or national origin. Enforcement of the Michigan Elliot Larsen Civil Rights Act. There are two agencies that you can make a claim with for the ELCRA on a federal and a state level. A claim can be made two ways, either with the state administrative agency, which is the Michigan Department of Civil Rights, or the MDCR, or with the federal administrative agency, the Equal Employment Opportunity Commission, or the EEOC. These two agencies have a working agreement that they will work together to process the claims. You don't need to file a claim with both agencies as long as you indicate that you want to cross-file it with the other agency. Additionally, the ELCRA covers employers of any size. This is important because the EEOC enforces federal laws which cover only employees with 15 or more employees. So if you're an employer that has between 1 and 14 employees, the ELCRA would cover any of your claims. When filing with the MDCR, the claims need to be filed within 180 days of the alleged action. The MDCR will then investigate, and once legitimized, a formal claim will be filed with the employer. From there, it can be resolved mutually by a mediator or a third party, or you can move to a court claim. It is important to note that though the filing with the MDCR is not required to pursue a discrimination claim directly in court, as long as you have a lawyer. How is the Michigan Elliot Larsen Civil Rights Act enforced in organizations? Referring to what I stated before, if no reasonable resolution is found, the MCDR can take other actions. These actions can range from hiring, reinstatement, and promotion of an employee that was involved with the claim, payment of back pay, admission or restoration of individuals to labor organization memberships, payment of damages for injury or loss, payment of complainant's costs including reasonable attorney fees and expert witness fees. Also, looking at the enforcement of the ELCRA in the workplace, employers that are subject to the ELCRA are required to display the Michigan discrimination law poster. This poster is very easy to find. It is on the MDCR website and must be displayed in a location in the workplace where employees can actually see it. Also, it's important to note the main purpose of the enforcement of the ELCRA is to seek remedy of the discriminatory conduct. Next, I have two cases that demonstrate discriminatory claims under the ELCRA. One is based off of age, and then one is also based off of gender. So case number 1, Bill Walter v. GIGP. The basics of the case is that Bill Walter's father started a medical practice, and in the interest to secure his son's financial security, since his son was a non-doctor, he created a unique job for Bill and contractually promised Bill that he would always have a job in the family practice. The job that he had consisted of basically an office manager. Later on, the defendants knew about the contract between the two, but still went back on it. What the basics of it was, the doctors or the defendants wanted to take the salary and disperse it back amongst themselves. They had planned on getting rid of his position, but chose to terminate him based on his age. So, the defendants met with the hospital group's CEO and agreed that because Bill was turning 59 and a half in July of 2018, only 1 year and a month later, they would get rid of him. Bill had made claims that he wanted to retire at 65, since that's the time when he felt that he would be able to live off of his savings. He had no intention of retiring before that. Defendants knew about the lifetime contract but still sped up his retirement and used his age as a factor for termination. The case was settled for $125,000 in favor of Bill, and one of the reasons that led to this is because that he had an ELCRA discrimination based on age. It didn't help their case. Next, case number 2 involves a discrimination under the ELCRA based on gender. Carrie Howard versus Ross Mortgage. The plaintiff, Carrie Howard, worked for the employer for numerous years. When she was diagnosed with a cancerous kidney, she elected to use time off under the Family Medical Leave Act. Before leaving, she was in multiple situations where she was pressured by her boss to put false information on mortgage loans. While recovering from her surgery, her boss made the decision to terminate her employment before she was able to return to work. An eyewitness or a coworker provided a recording that showed the rant of her boss that included the statement of, "As soon as she walks back in through those doors, I'm going to fire her." The actual video does show that he used more colorful language, not much more, but there were also multiple claims of derogatory comments about women from the same boss. The defendants were caught in multiple cover-up lies, including the offering the plaintiff a job at a different location, and claims that her boss never made the claim, despite having a recording as proof. The claim ultimately settled for $90,000 in favor of Carrie. Though ELCRA discrimination wasn't the main factor in this, it did help her case. Now that we have provided some examples, background, and some laws that go along with the ELCRA, I have some suggestions for employees. These are for both employees that are in hiring positions or maybe just employees that are on the base level. The first one I have is make sure that there are policies and procedures in place that will eliminate or reduce the number of situations that create these claims. Next, employees should feel free that they can talk with specialists about whether they are taking the right steps. This is for companies that may have a legal aid on staff or any other one. It's important for employees to feel that they can talk to people to make sure that they are taking the right steps to make sure their procedures are discrimination free. Next, always look for new information and furthering your knowledge. This is both for hiring employees and employees. You have the right to know this information, so don't feel like you're not privy to this information. Next, make sure that all the required information is posted for employees to be informed about their rights are. Next, use online resources such as discrimination prevention checklists and other resources to make sure that your policies are truly discrimination free. Thank you very much, and on the next slide I do have a slide for my references.